Welcome once again to Lehto's Law. Here's Steve Lehto.
This is a follow-up to a story I did a while back, and it's a funny ending to a story, although I guess this isn't the end, but this is the second chapter, but it's a funny one nonetheless. Tim passed it along, but so did several other people, and I appreciate that because I do try to follow the news. I subscribe to several newspapers, and I read 3 or 4 every morning. And during the day, periodically, I check them also. But once in a while, if I cover a funny story from some corner of the country, the follow-up won't cross my desk the same way the original one did. So thank you very much to everyone who passed it along. Psych evaluation ordered for man who sought trial by combat. This is out of Harlan, Iowa. And this story broke about a week or so ago before other recent events in the news. And the funny thing is, if you study the history of legal conflict, the idea that people have got complaints about other people and how they settle them, they used to, of course, settle things by duels. Dueling was something that actually happened in America. And dueling, of course, eventually went away. But there was a time when they actually settled things with trial by combat. And I'm talking back in the old days, where, you had a feud going with somebody else, or you really thought somebody had wronged you, you could challenge them. And in a roundabout way, it's almost like a duel, except that it was not uncommon that you could get someone to stand in for you, and then somebody else would stand in for them, and they'd fight about it. Hey, let's the two of them fight. So, but this is an interesting turn in a modern story, because an Iowa judge has now ordered a psychological evaluation of the man from Kansas who asked the court to let him engage in a sword fight with either his ex-wife or her attorney so that he could rend their souls from their bodies. Now, this is the problem, and I may have alluded to this in the original video, is that you say something like this, and it's funny, and it makes the news and gets people like me talking about it. Otherwise, I would never have heard of this man before. But the problem is when you get attention like that, it will cause people to look at you and go, is the guy serious? Because the idea that you want to kill somebody is not something you want to voice. And if you're just kind of saying things, that's not a good thing either if you're involved in a court case. Because courts do have to look at the parties in front of them and say, are these people sane? Now, many people are sane. I was going to say most, but I changed my mind as I was saying the sentence. Many people are sane, and the courts don't have to address it. But if you do something crazy in front of the court, or say something crazy to the court, or file something crazy with the court's got to look at that and go, okay, if they're serious, that might be a legal problem. If they're crazy, that's another problem altogether. So the idea that you want to rend the souls from the bodies of your ex-wife and or her attorney is going to raise eyebrows. The man is from Powell, Kansas, and he said in a January 3rd court filing that his former wife of Harlan, Iowa, and her attorney had destroyed him legally. And that's a quote, destroyed legally. Now, they didn't destroy him physically, they destroyed him legally. So the interesting thing is that when he says he wants to rend their souls from their bodies, and rend their souls is an actual quote. To rend their souls from their bodies is a physical thing, not a legal thing. And believe it or not, that's actually where most attorneys, when they hear this, go, okay, he stepped it up a notch. And it went from a legal threat to a physical threat. That's why suddenly this got interesting. The couple, or former couple, have been embroiled in disputes and arguments over custody and visitation issues, as well as who's going to make the property tax payments on property that the two of them apparently have interests in. Now, the man filed a document with the court telling the court that the court had the power to let the parties resolve the disputes on the field of battle, and that resolution would be legal. The man added in his filing that he filed with the court that trial by combat has never been explicitly banned or restricted as a right in these United States. That's an interesting thing. I'm not sure that you ever had that right. That's the bigger question. There's all kinds of things that have not been restricted, But, I mean, is there actually a law saying I can't let a UFO park on the roof of my house? But, it's another story altogether. The man said that apparently a lot of his beef was with the attorney for his wife. And he says, I think I've met his absurdity with my own absurdity. Adding that his former wife could, if she wanted, let her attorney act as her champion. And the champion, like I said, is the person that gets to stand in for you and do the battle if it's trial by combat. So he's basically saying, look, I want to take a sword out in a field, and my ex-wife can have a sword, and either she can fight me with swords or her attorney can. The wife subsequently asked the judge to suspend the man's visitation rights and ordered him to undergo an evaluation, which the judge did both of. He suspended the visitation rights and he ordered the man to undergo an evaluation. So the man actually moved his case backwards. Okay, you're trying to move the ball this way and suddenly you find yourself losing yardage, to use a football expression. The judge said in the ruling, this conduct is concerning. The content of the messages sent through email by the husband or the ex-husband over the past few months is disturbing. His motion for trial by combat is disturbing. His reasons for filing the motion in order to get publicity is disturbing. And, this is one of those things. I don't talk a lot about family law on this channel, but I talked about that crazy divorce case out of Oakland County where they've gone through like 11 attorneys and hundreds of docket entries and so many different judges and up on appeal and everyone hates everybody. And it's, and people who are removed, who step back and just look at it, don't know any of the parties, don't know the judge. You just literally just look at the mess that's happening. And they look at it and they go, there's adults in there. There are adults in there. There's just children in there too, unfortunately. But there's adults in there who aren't acting like adults. And we've all met those people who hate their exes. Just bitterly hate their exes. And you're allowed to have emotions. You're allowed, no law against that. That's one thing the law is not outlawed yet, is your emotions. But when you go into court and you're trying to resolve something, okay, the courts are there to try to, they're going to try to help you resolve something, whether it's a visitation issue or a property issue or the taxes on the property, whatever. And when the court sees people acting in a non-adult fashion, whatever that may be, crazy, childish, whatever, it doesn't help. And one of the adages that I had never heard before I went to law school, and it didn't really become clear to me until after I graduated from law school and became a lawyer and had been involved in many settlement situations. And I admit, I don't do a lot of family law. By that, I mean I do zero. I avoid it like the plague for this reason. Don't get me wrong. If someone challenged me to trial by combat, I'd consider it. But I think it's illegal, unfortunately. But I'm joking. The point is that when two parties are suing each other, they disagree over something. And let's take it in the concept of my cases. My client bought a defective car. The manufacturer sold them a defective car, in essence. The law says that the manufacturer must make this person whole, either buy back that car or compensate them for the trouble they've been through or trade them into a non-defective car. As you can imagine, a lot of consumers who've been put through that situation and are forced to go to court and file a lawsuit and spend months litigating a case that they think that there should be a clear slam dunk ruling on, they're upset by that. Why do I have to go through all this hassle? And many of them are very wound up and very upset by that. And we go to court and we encounter an attorney, oftentimes from a corporation, who comes into court and goes, well, my client doesn't see what your client's all upset about. And, here's what we'll pay. My client wants this. They want this. They want to pay this. Client wants this. You'll see there's a difference there. It's kind of hard to see, but there's a difference there. The difference is this, okay? That difference is the gap that we must bridge to get these two parties together. What's it going to take to get you guys together? And it usually involves both sides giving up a little. Okay? It's possible sometimes where one side can say, screw you, we're digging in our heels right here, you pay us $1 on $1 or we'll see you in court. Now, I've once in a while seen that work as a concept to settle a case where somebody goes, I'm digging in my heels right here. This is what I want. The other side goes, fine, we'll pay it. But more often than not, when someone digs in their heels, the other side goes, fine, we'll go to court. We'll roll the dice. Jury could give you everything you want. The jury can give you zero. Or the jury can go out in left field and give us something that neither of us are anticipating. Juries do that. So, to get a settlement where both parties stand in front of the judge and go, Your Honor, we're ready to settle the case for this, it usually involves both sides giving up something. And that means, by definition, that neither side got what it wanted. Neither side is 100% happy. And I've had this discussion with many clients before. And I say, you understand, you wanted $1. They offered you 50 cents. Now, I'm not saying the case needs to settle for 75. But the point is that if they pay 75 and you take it, you'll be upset that you took a little less than you think you're entitled to. They're going to be upset because they think they paid more than they're entitled to. And that difference is something you have to live with unless you want to go in front of a jury and roll the dice. And I've tried enough cases. I can tell you, I've seen juries where the range is this, and it doesn't matter which way the spectrum goes. And the jury gave somewhere in here the same result as if we'd settled. But I've also seen it where the jury goes, no, we're over here. Completely screwing the other side. Or, jury's over here. Completely screwing the other side. It happens. We've all seen those cases in the news. So the idea that you're unhappy with the resolution that you got from a court, join the club. Everyone's unhappy. That's what happens. Unless you go to trial and rolling the dice, you're the lucky one where the jury came back in your favor in a crazy way. Because if they just gave you what you're entitled to, you still went through a big lot of hassle to get there. Time is actually got some value to it. But I'm not saying that you'll never get what you're entitled to if you go to court. But I'm just saying that unfortunately, a lot of people think they can hold out and get everything they think they're entitled to when everyone around them is saying, look, this right here is a reasonable settlement. You should take this. Unless you want to gamble and try to get more later, okay? It's not let's make a deal, but it's close. So this guy who's unhappy with what's happening, and he says he's been destroyed legally, and he wants to go out in a field and kill the attorney and or his ex-wife. When he says that to the court goes, okay, now he's no longer in the realm of normalcy. He's actually gone into some kind of second dimension, which ain't right. So the man told the Des Moines Register that he has an appointment scheduled with a psychologist. He said he can ask the judge to reverse the decision about contact with the children if the psychologist determines he's not a threat to himself or his children. So, like I said, not moving the ball this way, moving the ball this way, because he was upset about something. He filed some crazy stuff with the court. Now the judge says, tell you what, you can't see your kids till a psychiatrist says you can, or a psychologist. If he has to undergo treatment, the man said, he must wait until the program is complete to make the same request. So at the time he made the request about trial by combat and to rend people from their bodies and souls, he got headlines. I'm sure he thought it was funny at the time. Some people don't think it's funny. And that's what you get. So, Tim, thanks for passing along the story. That's the update. Questions, comments, put them below. Otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. When you need a helping hand, start with the end of your arm.